Welcome and thank you for taking the time to join our live webinar today. My name is Chelsea Goodhughes and I am the marketing coordinator for the Kopenbarger and Kopenbarger law firm. We have been in the business of protecting families like yours for over 40 years and have 300 years of combined attorney experience in areas of estate planning, estate administration, business and tax, and litigation. With 7 different locations throughout the state of California, our attorneys and support staff are ready to serve you anywhere, at any time, and have the ability to conduct meetings both in person or through virtual means such as this. Your presenter today is attorney Stephanie Delaney, and she is one of the 9 attorneys within our firm. Stephanie works in the Estate Administration Department and works mainly out of our Orange County office, while also working towards a dual master in tax law and business administration. Stephanie is a wonderful attorney who knows the ins and outs of estate administration and is dedicated to serving every client's needs to the best of her capabilities, both in office or in the court. Here she is, Stephanie Delaney.
Thank you, Chelsea, and thank you everyone who's signed on. I am excited to go over this topic with you guys. It's a very important one. We're going to go over the administration and how the process works in naming a successor trustee of your estate and how you should select that person to be in charge of your estate after you pass away. We'll also touch on some probate matters and incapacity as well, and how important it is to plan ahead. So here's an agenda of the topics we'll discuss today. We're going to go into more detail for each one. But to start, we're going to talk about what is an estate. So a lot of people aren't familiar with what this means. We're going to go in depth about it, talk about what if there are assets that are not held in your trust, what happens then, and how the probate process works. If you're named as successor trustee, what exactly does that mean, and what rules do you have to follow? What are your duties, and how long does the trust administration process take as a whole? We're going to go into the difference between trust administration and probate and how you can successfully avoid probate, which is the goal. Some common concerns that beneficiaries have and how your duties as successor trustee can be violated. And then lastly, how our office can help. So the first thing is, what is an estate? So an estate is all the money and property owned by someone at the time of their death. So this is bank accounts, stocks, bonds, life insurance, retirement, pensions, social security, real property, vacation rentals, cars, boats, jewelry, everything. So it's everything you've accumulated over the years. As far as probate, there are 2 ways to look at probate. Basically, a probate during your life is a conservatorship. A conservatorship is where a guardian or a protector is appointed by a judge to manage your financial affairs and your daily life of another due to their physical or mental limitations or old age. And then the other probate is a probate after someone's lifetime. Both of these processes require going to court, which is not exactly a great thing. It's something we want to avoid because going to court is expensive and it's time consuming. I also want to bring up incapacities. So incapacity administrations are also, they come into play most often when a mom, for example, when a mom or a dad, they're starting to lose their mental capacity and are unable to manage their financial affairs. Basically, an incapacity administration, it essentially starts a trust administration before someone passes away. So probate. Probate is expensive and long. It can take 18 to 24 months. The control is completely with the court and not with the family or loved ones. As far as costs go, For conservatorships, it's an hourly rate, and then probate is statutory. So probate occurs when someone dies, even if they have a will and they have assets that are not in their trust and they're held in their name alone with no beneficiary designation, and all of their value of those assets, or one single asset, if that exceeds $166,250 in value, you'll have to go through probate. It's a very specific number, but it's a dangerous one. You want to stay below that number or have all of your assets protected in a trust. I know some lawyers love doing probates because some of them don't take a lot of work, but because of the fees and how they're statutory, they can make a lot of money doing them. And again, on probate, the court sets all of the dates. You're kind of at the mercy of the judge's calendar and their availability. I know particularly with COVID-19, our petitions for probate have been pushed out as far as 9 months from the date of filing, which is super, super far. Like, you definitely don't want to have to go through this. To put probate versus trust administration into perspective, if someone died with the house and it was held in their name alone, meaning not in their trust, and the house is valued at, say, $600,000, and there's one child and they're the sole beneficiary, the estate would have to be probated, and the administration, it could take 18 months or longer, and it'd cost probably around $20,000. Now, if you had, using the same facts, if you have a trust, the trust administration would probably cost around $3,000 to $4,000, and it could probably be completely completed and wrapped up in 4 to 6 months. And so that's why it's so crucial to have a plan and have your assets protected, so you don't have to be caught up in the court system and someone else's timing. So the estate administration process is the process of carrying out the plan that you created, how you want things to go after your lifetime. You have the complete ability to control this. You can decide if you want to donate some of your assets to charities, or if you want it to go to your children. You get to customize everything. If you currently have an estate plan, make sure your trust is properly funded. So this means making sure and confirming that your assets are titled correctly, so there are no surprises after your lifetime. I've seen many situations where clients have a house and they sign deeds and everything to put it into their trust, but they never recorded them. And so it's a huge surprise after mom and dad die that they find out their trust or their house was not in their trust. So that's another very important thing, is to make sure your trust is properly funded. So what is a successor trustee? A successor trustee is ultimately responsible for making sure your trust assets are distributed according to the original trustee's wishes. So when choosing someone to do this, there are a few things to keep in mind. First, you should choose someone who you know will be committed to completing this, because it can take a long time, and you definitely want someone that you know will be responsible and organized, and they'll see it through to the end. So the primary responsibility for a successor trustee is to marshal all of the assets. So this is when someone passes away, the first step is identifying and collecting all of their assets and property, which can, again, take a ton of time. So choosing a successor trustee is a decision that shouldn't be taken lightly. It's not exactly an honorary position because of the work and commitment, but who you choose is responsible for making major decisions for your estate. So who can you choose to fill this role? A lot of people have their spouse, their significant other, their sibling, adult child, and you can even name your attorney in some cases. It's always a good idea to have 2 or 3 options, just in case the first person named is unable to fulfill the role. So this is a big picture overview of what needs to be done as soon as someone passes away. So updating land records. So as successor trustee, if there's real property, the land records have to be updated with the county assessor and county recorder's office. So this means essentially removing the person who has died, removing their name off of title. Another thing that needs to be done is notifying beneficiaries. So the law requires that a notice be sent out to all trust beneficiaries and heirs when a trust becomes irrevocable, meaning no one can make any changes to it, it can't be amended, or when a portion of a revocable trust becomes irrevocable, or when an irrevocable trust has a change in trustee. So a notice has to go out. Another notice that has to go out is to the Department of Healthcare Services. They have to be notified when someone passes away. This is mainly to confirm that there's no existence of fraud. So we want to confirm that the decedent was not receiving Medi-Cal benefits. And we also need to lodge the original last will and testament of the person who passed away. So this is not a copy of the will, we need the wet signature original will. And that goes to the Superior Court where the decedent resided, and the courthouse keeps the will for safekeeping. Then we also need to obtain what is called, in short, a TIN. So this is a taxpayer identification number. So depending on the type of trust, the successor trustee will need to obtain this TIN number with the IRS. And this notifies the IRS that you or someone as successor trustee is now in charge of filing fiduciary returns or personal income tax returns for the decedent. So it puts everyone on notice, basically. And these big picture items are all things our office likes to do right away. When someone passes away, a lot of these are time sensitive. So, and we'll go through these. If you have an appointment with us, we'll go through these in detail so you're aware of the exact time frame and deadline of getting these things done. So this slide, as far as finances and taxes go, our firm is able to be a full service one-stop shop. So this means we have bookkeepers and CPAs on hand to take care of all of this in one step. However, I will say the person that you've chosen to take care of these things should be someone you trust to manage your finances after your death. Because they'll have access to all of your accounts and will be responsible for taking care of these financial obligations. So you don't want to leave that kind of power with someone that might have the potential to abuse it, even if it's not intentional. Maybe they're just not good with managing money. That's definitely something to take into consideration when choosing someone. So just briefly to go over each one of these bullets. For personal income tax returns, the successor trustee is in charge of filing the decedent's personal income tax returns. For fiduciary income tax returns, the same thing, but it's for the trust. So the IRS requires the filing of an income tax return on Form 1041. This is because trusts and estates must pay income tax on their income, just like you would report on your own income tax return each year. And then for estate tax returns and estate portability election, the estate tax doesn't apply to the majority of people. This is because the estate tax exemption is $11.58 million, which is extremely high. So as long as the total value of the decedent's estate does not exceed that huge number, 11.58 million, no estate tax return should be due. However, there are certain people that this does apply to, and if you have serious concerns about this issue, please make an appointment to discuss that with us and how we can help your family and file a portability election to help save a significant amount of money when the other spouse passes away. For income tax basis, any real property or stocks, securities, anything that fluctuates in value will receive a new income tax basis for capital gains purposes. And that's equal to the value of that property as of the decedent's date of death. And calculating that value is something our office would do. And then property tax, similar to the estate tax and portability election, if property tax is a major concern of yours, be it that you have several pieces of property or you want to figure out the best way to get property tax exclusions to pass down to your kids, that's another great reason to come in and talk to us and have an appointment. Because there's definitely exclusions to go over. In short, regarding those exclusions, there's a real property, if there's real property being transferred between spouses, it's excluded and exempt from reassessment. And also if it's transferred from parent to child, it's also exempt from reassessment. So this is the probate code. All of these rules relate to the trustee's duties. So a common question a successor trustee might have is, who is making sure I'm following the rules? And can I get in trouble if I don't follow the rules? And most importantly, what are the rules? So these are the rules laid out right here. To answer that question in short, the court makes sure you're following the rules as well as any heirs or beneficiaries. Out of all of these rules, I would say some of the most important duties that are often breached are the duty of loyalty and the duty to deal impartially with beneficiaries. This means as successor trustee, you can't play favorites with beneficiaries, and you must administer the trust solely in the interest of the beneficiaries and not for your benefit. So for example, I worked on a trust administration and discovered that the trustee was using trust money to get her nails done and get her hair done for her own personal salon appointments. And obviously this is a major violation of a trustee duty. So please don't do that. Okay, so some common beneficiary concerns that come up are lack of communication, delay, perception of favoritism, perceived absolute discretion, lack of communicating with your attorney, lack of follow through with the settlor, beneficiary being told they were going to receive everything, and then not receiving a copy of the trust. So I'm going to go into each one of these in detail. But these are some issues that can come up in your role as successor trustee. So lack of communication. Handling an estate and executing a will or trust often involves a lot of detailed paperwork and signatures and deadlines. So making sure that you've chosen the person who's organized and can focus on details and is good with communication is very important. I would say communication is key, communicating with our office, beneficiaries, or financial institutions. Also, because trust administration, probate, incapacity, or conservatorships can cause emotions to run high within families, it's important to also choose someone that's level-headed, neutral, and rational. Very important. Back to communication. Trustees have a duty to keep the beneficiaries informed with what's going on with the trust. They're also required to account to beneficiaries once a year. An account is basically, it's a financial statement regarding the financial transactions of the trust. So it shows everything that has gone on, everything going in, everything going out that you have done as successor trustee of the trust. So that's very important to keep adequate records as successor trustee. It will make your life a lot easier if you have it all organized. I had a client who had meticulous records. Everything was tabbed and organized. And so when the time came to send a report to beneficiaries, it was super easy and quick. On the other hand, I've seen trustees that don't keep records of anything. And so we've had to work backwards and kind of get everything together. And it took a significant amount of time and money. And the cost of the account and the report comes out of trust money. So you definitely want to keep that as low as possible because it's coming out of beneficiaries' inheritance. So another issue that can come up is delay. So trust administrations usually take between 12 to 18 months, which sounds very long. And again, that can vary depending on if the trustee is organized and keeps records. It can be a lot quicker. And I'll go into more detail about why it can also take a long time. If the trustee is organized and great with communicating with us, the trust administration can be fairly quick as maybe 5 months in some instances. It just depends on the type of trust and the assets involved and the distribution provisions. So this is a big one, perception of favoritism. In trust administration, family issues and tension is natural. It's even more so important to follow the trustee's duties in a situation where there could be hostile siblings or people that are upset that you're named. So it's even more important for the successor trustee to follow the rules and do a great job in their role to avoid any conflicts. This brings up a topic of co-trustees. And having co-trustees can be very difficult. I personally have dealt with some headache trust administrations because co-trustees couldn't get along or they'd fight constantly. Some even end up having to go to court about it because they just cannot agree on a certain issue. And anything that involves the court is at least $10,000. So it's definitely something you want to avoid. In my experience, it's been a smoother trust administration if there's been a sole trustee versus co-trustees. If you currently have co-trustees named in your estate plan, this is definitely something we can go over together and talk about whether that's a good idea or not, and maybe update your estate plan or amend it just for that section, the successor trustee section. So lack of communication with your attorney. Again, keep open communication with our office as life changes. We can always update your estate plan. Also keep in mind geographical proximity for your successor trustee. Although it's not necessary to choose someone who lives near you, it may be a deciding factor for you. I will say with COVID and the ability to do Zoom, it's definitely possible to have an out-of-state trustee if that's the person you want to handle your estate matters. It's more than possible to do. But some people prefer to go into the office and come in and work with us directly. So that's something to think about with the successor trustee and talk about with them. And just as an example of how important it is to keep in touch with our office and updating your estate plan as necessary, I had an unfortunate experience with a client where he suddenly had a severe heart attack and he had to be in hospice, and he called frantically wanting to update his estate plan, in particular to change his successor trustee. And that's just, even after having a heart attack, that's something that shouldn't have to be dealing with, that type of stress. So it's just such a great idea to stay up to date. If things change, let us know. We're definitely here to help as life changes for you. Okay. We discussed the notice requirement a few slides back in the notice that needs to go out to beneficiaries or heirs when someone passes away. And part of what's required with a notice is that a copy of the trust is sent to any beneficiary or heir. If this is not sent within the required time frame, the trustee has violated this duty. So it's important to make sure that's taken care of. And by the way, again, if any time frame or deadlines required throughout probate or trust administration or incapacity is discussed in detail during our meetings. So as far as the overall administration process, when you lose a loved one, the most important thing is to grieve and to take care of your family. Take your time. We're always here. You can call us. Please let us know if there's an incapacity or death in the family. Then I would locate any estate planning documents you can find. Schedule an appointment to come in and go over this and gather any important documents. If it's a trust administration, we'll need a death certificate, asset information, and that's something we'll give you a list of the items we need over the phone when you call to report the death. And then meeting with an attorney would be the next step. One final thing I wanted to make sure to point out is before giving someone the responsibility of being successor trustee of your estate, make sure you talk to them about whether that's something they would want to fulfill. Some people may not feel like they're up to the task because they have too much going on in their life, or they wouldn't be able to set aside their grief to do all the tasks of a successor trustee. But also know that our office is here to help you. I know some successor trustees want our office to essentially hold their hand throughout the trust administration. They kind of just want us to do it all, just take care of it. And we can definitely do that. And some successor trustees want to do as much as they can on their own and just keep us around if they have questions or any big challenges come up. We're here for that too. The main takeaways from today are: you want to avoid probate. Please plan ahead with your estate. Also, while you're updating your estate plan and making sure everything's intact, it's not a bad idea to make sure the person you've named as successor trustee has updated their estate plan as well, or even make sure they have an estate plan. The more you can plan now, the better it'll be for your loved ones after you pass away, so they can carry out your wishes. That's all I have today. I want to thank you guys so much for joining. And I am going to hand it back over to Chelsea.
Thank you, Stephanie, and great job. For over 40 years, Cope & Barger Law Firm has helped thousands of families through the process of both probate and estate administration. It is imperative to have a proper estate plan in place to avoid stressful situations for your loved ones after you are gone. With over 300 years of combined attorney experience, we are dedicated to handling each estate with utmost care, so you can rest assured that when you come to our office, you are greeted with warm coffee and friendly faces, whether you are reviewing your estate plan, establishing one for the first time, or administering a trust after the loss of a loved one. Now that you have heard all the tasks and responsibilities that go into a successful administration, we ask that you pull out your estate planning documents, dust them off, and read through them to ensure you have the proper people selected for the job of successor trustee. We also encourage you to reach out to those you've named in your own estate plan and make sure that you have a proper plan in place for themselves. If you do not yet have an estate plan in place, the time is now to protect yourself and your family from the hassle and stress of probate. If you would like to meet with us to discuss either estate planning or the administration process, please click the link in the chat box and send us your first and last name along with your phone number, and we will reach out this afternoon and get you the answers you need. Remember, we are here to help you through all stages of life and appreciate being your expert referrals for all of your professional needs. We look forward to serving you and your family for many years to come. Thank you.